Chairman Kappinga, Chairwoman Nedweski, and members of both committees, thank you for the opportunity to testify today. My name is Kyle Koenen, and I serve as the Policy Director at the Wisconsin Institute for Law and Liberty, or nonprofit law and policy center out of Milwaukee. With me today is my colleague, Lucas Vebber, who's a Deputy Counsel at Will. We are here to testify in support of all the bills before you today. We want to thank all the authors for their leadership in advancing these important reforms.
Good morning, committee members. My name is Lucas Vebber. Before diving into the particulars of each proposal, we just wanted to very briefly begin with some background on the separation of powers and why the rules governing it matter. Our Constitution lays out a clear framework on how government operates that we all learned in fourth grade. The legislature writes laws, the executive carries them out, and the judiciary interprets them. At statehood, the courts zealously guarded the separation of powers. Laws had to be complete in all forms when they left the legislature. They didn't leave anything up to fill in the gaps. Over time, government grew, and as government grew and agencies were created and expanded, the legislature has gradually delegated portions of its lawmaking authority to the executive branch. Courts allowed this to go forward over the years, and in exchange for this delegation, the legislature historically retained tools to control and have oversight over that agency action to ensure that the executive branch stayed faithful to the legislature's intent. After all, it is the people of our state that has empowered you all and only you all to write laws. They trust you to do that. They send you here to do that. But a recent court decision that we've talked about a little bit today, Evers v. Markline, found that many of those most important oversight powers were unconstitutional. As a result, the delegations of rulemaking exist, but the check on the back end largely does not. Without those tools in place, agencies will likely push beyond what the legislature has authorized over time, whether intended or not, just weakening accountability and undermining the rule of law.
Yeah, while some regulations are needed to protect health, safety, and welfare, they often are overbearing and come with significant trade-offs. Each new rule imposes costs measured in time, money, and compliance burdens that ultimately fall on your constituents. In particular, small businesses bear a disproportionate burden from excessive regulation, diverting limited resources away from growth and innovation towards paperwork and compliance. Families, meanwhile, face higher prices, fewer choices, and delays in everything from building a new home to accessing medical care. These hidden costs rarely appear on the balance sheet or in a budget vote that you guys take, but they are felt every day by the people you represent. In my testimony, I've highlighted a couple of examples of rules over the years that have either recently been introduced that have an impact or that the legislature actually used some of their oversight powers to reverse, and I'll just go through those quickly. Obviously, I think the probably one of the ones that's garnered the most attention in recent months is changes to the commercial building code. Stakeholders have been pretty consistent in saying that those rules will increase the cost of building multifamily housing, which will then be passed on in higher rents to your constituents. Another one that's gotten quite a bit of attention is new livestock fees from DATCAP, going on a number of different licenses, but one of the licenses fees will go up by 1,700%. That will raise costs on farmers and agricultural businesses. A couple other ones that the legislature over the years has actually used their oversight powers to negotiate with agencies and improve the overall rules. A couple years ago, DATCAP attempted to apply commercial pool code to short-term rentals that would have effectively banned any short-term rentals from having a pool or a hot tub in place. That would limit consumer choices. Obviously, that's something that Wisconsinites enjoy when they rent a place, but the cost that would have borne would have been prohibitive for most small businesses. And then back in 2019, there was also a DATCAP rule that would have imposed, would have required home bakers that sell at farmers markets and such to apply with commercial kitchen code, and that would have imposed significant costs on them from being able to do what they do best. So all of those both those provisions were moved, and they move forward as is. So I think those are just examples of rules that do impose costs on your constituents. So I'll move on to testimony on the Sunset Bill. So as been previously stated, Wisconsin is the 13th most regulated state in the nation, second most in the Midwest. That means our citizens and businesses face more restrictions than nearly anywhere else in our region. Yet once a regulation is adopted, it typically remains in effect indefinitely, regardless of whether it continues to serve the public interest or not. AB 274 and Senate Bill 277 create a 7-year rolling review process to ensure outdated, duplicative, or unnecessary regulations do not linger unchecked. Without sunset review, regulation becomes a one-way ratchet, constantly adding new costs and burdens while rarely removing them. By requiring agencies to revisit their rules regularly, Wisconsin can promote greater accountability, adapt to technological and economic change, and reduce unnecessary burdens on families and businesses. This reform provides a structural check that strengthens oversight, cuts red tapes, and ensures that regulations are effective. I'll just note that many states across the political spectrum have sunset review laws in place. By my count, there's 11 states that have broad sunset provisions, and a number of other states have more limited ones where they'll sunset particular programs or look at different rules. Colorado, not exactly a conservative bastion, has long been regarded as having one of the strongest sunset laws in the country. North Carolina requires every rule to be reviewed once a decade, and Idaho goes even further, forcing an annual review, or annual expiration of the administrative code, and then they review 20% of the administrative code each year. And I'll just note that several governors have also taken kind of the mantle of reducing regulatory burdens through a similar approach. In Virginia, Governor Youngkin has cut nearly 27% of the regulatory requirements, saving residents over $1.2 billion annually in compliance costs. And I think one great example of the impact, they've found that reductions in housing construction costs have cut the cost of a new home construction in Virginia by $24,000.
Thank you. I'll talk just very briefly then about AB 275 and Senate Bill 276, which is I'll call it the Access to Justice Bill. Another problem that we have under current law is that when Wisconsinites successfully challenge an invalid rule, they must still bear the full cost of litigation, including any appeals. And again, I think this is an access to justice issue. This discourages ordinary citizens and businesses, primarily small businesses, from taking on state agencies when their rights are believed to be being violated. They have a choice to make. They can either pay an attorney and go to court to right the wrong and bear the full cost of that, or they can take them on pro se, represent themselves, and try to do what they can. I can tell you from litigating these cases over the years that the attorneys at the Department of Justice are very good, and that's a difficult task. Or they do nothing, and they don't bring it, and they just live with what they believe to be as a violation of their rights. This bill fixed that by allowing a fee shift, so that when a court determines that an agency is unlawfully enforcing a rule, the citizen who brought the challenge can be reimbursed for those legal costs. It opens the courthouse doors because more private attorneys will take these cases, just like we do with public records cases. So right now, if you believe there's a violation of the public records law, you can go to an attorney. The attorney will likely take that case on contingency, will go get those records, and if successful and they get a court order, they can get their attorney fees paid on the back end. As a result, private attorneys are more likely to take those cases. This applies that same principle to violations of administrative rulemaking. So if, for example, a state agency is applying a new policy that hasn't gone through the rulemaking process as part of an application for a license or something along those lines, and they deny your license because of that, and you challenge it, you could get reimbursed for it. It opens the courthouse doors in ways that haven't been before. And I think those more cases, yes, it will lead to more cases, at least in the short term, is a powerful deterrent effect. I think the very existence of the fee shift will make agencies think twice before stretching their authority. You'll see a little bit more litigation by letterhead. I think your average everyday Wisconsinite can push back a little bit on the front end and maybe gets these agencies to work with them a little more. I'm not saying it happens all the time, but when it does happen, it's a problem. In this way, this legislation strengthens oversight and accountability by promoting better rulemaking on the front end and helps ensure that agencies respect the boundaries of their legal authority and helps protect the rights of Wisconsin citizens who otherwise could not afford to bring these challenges. Next, I'm just going to very briefly talk on the scope statement bill. Quickly touch on that. Scope statements are the critical first step in the Wisconsin's rulemaking process to give the public advance notice. I think this bill really has two parts to it. The first is that it requires a separate scope statement for emergency rulemaking and permanent rulemaking. I think that's an important reform because those are two very different things. Emergency rulemaking is for an emergency. It's a temporary rule. It's only in place for 150 days. And it needs to be moved quickly for reasons that Legislative Counsel explained earlier. Permanent rulemaking is different. Permanent rulemaking, as it exists right now, stay on the book forever. This would split it up. So you have one scope statement for an emergency rule that's valid for 6 months, and then you have a separate scope statement for a permanent rule that would be valid for 30 months. It also requires then that only one rule be promulgated by each scope statement. I think there's probably been roughly maybe 20 scope statements that have led to multiple rules over the past couple sessions, if that. So it's not a huge problem, but it is very confusing for the public. As somebody who follows rules all the time, when you see multiple rules coming out from one scope statement, it can be incredibly confusing. And it's just about ensuring that your constituents and those in your district who are following these things can do so in the easiest and most transparent way possible. So.
And then I'll touch on the regulatory budgeting bill. So AB 277 and SB 289 adopt a regulatory budgeting framework. When an agency proposes a new rule that increases compliance costs on the regulated community, it must identify offsetting costs elsewhere. I think an important check on that, if it cannot, the rule must be affirmatively approved by both houses of the legislature before taking effect. Just as lawmakers weigh in on new spending in the state budget, costly regulations should be weighed by representatives that are directly accountable to their constituents. Under the bill, agencies would be required to estimate the compliance costs of any new regulation, identify savings from repealing or modifying existing rules. If they cannot balance the ledger, the regulation cannot proceed until the legislature explicitly votes to approve it. This creates a clear process that prioritizes rules with real public benefits while ensuring costly mandates are subject to democratic accountability. Other jurisdictions have pursued similar reforms with success. I know another speaker will probably talk on this a little bit, but British Columbia was kind of an originator of this. They implemented a regulatory budgeting system in the early 2000s, reduced its regulatory requirements by 40%, and they saw great results economically as a result of that. Ultimately, regulatory budgeting forces agencies to weigh trade-offs and prioritize rules that truly serve the public interest rather than continuously layering on new burdens onto Wisconsin families, farmers, and small businesses. In conclusion, the reforms before you today serve as an important check on this trend and a meaningful step towards reasserting the legislature's constitutional role as a lawmaking body. They're not a silver bullet, but they will ensure that there are real mechanisms in place to review regulations, rein in agency overreach, and hold the executive branch accountable. In doing so, they help restore the balance of power our Constitution requires and ensure that the laws governing Wisconsinites are made by their elected representatives, not unelected bureaucrats. And we'd be happy to answer any questions.
Thank you, gentlemen. Questions from the committee? Senator Larson?
Thank you. Thank you guys for your testimony. Given the depth of the details and the examples that you put forward and how you're testifying on all of these, are you the guys who came up with these bills?
I'd say we offered input to the lawmakers about direction on ways to reform the regulatory environment here in Wisconsin, especially given recent court decisions, but I wouldn't say they were ours. They are the bills of the authors.
Sure, but they haven't talked to, we've been discussing of who they talked to and who they reached out to, and I think one of the bill's authors cited you guys specifically, and a number of my colleagues have asked if they reached out to you.
Yeah, we did come out with a study that highlights some of the economic benefits. I think that's probably one of the big impetuses for working on these.
Gotcha. Okay, so you guys, that's it. And you purport to represent the interests of citizens. I think you've mentioned a few times that people are not being helped by this, and that you're purporting to be representative of individuals out there in the state.
Yeah, I mean, we're a civil rights litigation firm, so we represent the public interest, and yeah, so I would say yes, we're trying to represent average Wisconsinites that have their rights violated.
Who funds you guys?
Representative Bear?
Yeah, so hold on one second. I'm going to call some order here. For anybody who has been in the legislature for a while, like yourself and myself, I have never once seen an outside group who's funded by somebody that has not had a political bent and I've seen this line of questioning before, it's not appropriate to be asking any organizations or individual in front of us about their funding. The intent is to find out if you have questions about the bills. We need to get through that.
We have to
and
get to the source
question
of
that,
why these are
but
coming before us, Mr. Chair.
It doesn't matter what the intent is. The question is, do you have questions about the bill that you don't understand so you can make good decisions in public policy?
That's
'Cause-
it. I'm trying to figure out where they're coming from, and I get that there's.
Well,
there's
we're
a
not
lot
gonna-
of this
we're
is
not gonna be
wrapped up
asking them
in the
about where their
idea
funding comes
of
from,
who's being
son.
protected and who's being harmed, but I want to get to the source of actually who is driving this stuff forward, Mr. Chair. That's it.
Then
That
ask
gives
them
me-
about
that
the
gives me
bill, Senator.
motivation.
We don't want to get into another situation.
Just trying to get a peek behind
Stay
the curtain.
focused
Mr.
on the
Chair.
bill.
Just trying to get a peek
Thank you.
behind the curtain.
Representative Bear.
Thank you, Madam Chair. I'm curious about I had a line of questioning with Ledge Counsel about constitutionality on 274, AB 274, and I think that some of that I don't know what the right word is, but rebuilding the legislative veto as it was that the court found is a lot of what that bill does in particular, 274 does, and AB 277, I think, does a lot of the same, requiring there to be a new bill for a rule that has a cost if there's not agreement on how to move forward on that. And so, curious, I guess it's two-part first question of your thoughts on the constitutionality of both of those bills, and then with those concerns in mind, we've got one attorney saying that those are fair considerations for us, and potentially an amendment that may be in drafting, may not be. Somebody may be working on it, not clear. With those concerns in mind, I don't want our questions and grandstanding to indicate that we don't think there should be a legislative veto or a legislative check. Checks and balances are important. We have a role here. We I think, as legislators, value that role, and we should. And so how do we go about getting around the constitutionality concerns to really have a legitimate check on executive power?
Yeah, so,
It seems like these bills get us there.
yeah, I think I would just point out, these bills were all drafted and introduced prior to the Evers v. Markline decision coming down. So they were introduced before that decision ever came into force. So they were, the law as it existed before then is kind of was there. So I would certainly agree. I think there are some changes that would need to be made to the sunset bill to avoid some of the constitutionality concerns that our court made clear in the Evers v. Markline decision related to a legislative committee veto. I don't know if those concerns carry over into the budgeting bill in the same way, but would certainly warrant a close look at it. But I think that one's probably on more solid ground.
Okay, and so do you have thoughts on how we go about doing that proper legislative check on rules on anything in the executive
Yeah, I
branch?
think the court decision makes that extraordinarily difficult for the legislature. I think the power that has been granted over the years by the legislature was granted conditioned upon the ability of the legislature to exercise that oversight power. Those grants of power still exist. The oversight power largely does not. I don't know if there's going to be future litigation challenging those grants of authority, the delegations of power that came out. There may be. But I think it puts the legislature in a very difficult position on what you can do. Realistically, your only way to have a check on oversight in the rulemaking process now is to pass a bill and have the governor sign it into law. Of course, as part of the rulemaking process, the governor has to already approve any final rule before it gets to you. So you'd be asking the governor to essentially go back on what the governor said previously. But I think it's a difficult issue. I think this package of bills, though, with some of the amendments that we've discussed that may be necessary, goes a long way towards just ensuring the public involvement and the transparency and the sunlight on the process that is important for it. And I think, beyond this package, there probably are other reforms going forward. I think perhaps even a constitutional amendment to address the Evers v. Markline concerns.
Okay. All right, I appreciate that, and you can tell your funders, whoever they are, that I'd like to read the next version of the report that can do this in a constitutional way. Thank you.
Thank you, Representative. Any other questions from members of the committee? Representative Hong?
Good to see you gentlemen again.
Good to see you.
Great to see you often. I key stakeholder for the majority party, so doing your job and due diligence and making sure the advocacy is there. But since you are such a key stakeholder, and forgive me, I feel like there's a lot of oversimplification and not a ton of definitions going on when it comes to government and anyway. So rules and regulations stem from laws, and I believe the majority party has been in power in the legislature now for over a decade, and your organization also works closely with the majority party. Why were there not attempts to introduce laws that would have had, that would not necessitate as many rules and regulations through the committee?
I'll just say that we are not legislators. I think you'd have to ask your colleagues. We have regularly put out information on ways to improve Wisconsin's regulatory system consistently over the years. Our organization has only existed for 12 years or so, so we're not that old of an organization, but we are consistent that this is an important, separation powers is an important, plank in our mission statement. So we've talked about this from both a policy perspective and litigated on it extensively. So we put the information out there.
Yeah, and administrative overreach is certainly not a partisan issue. We've sued the Walker administration, we've sued the Trump administration, we sued the Biden administration, we sued the Evers administration. We are a nonpartisan organization. We will defend against administrative overreach no matter who's doing it. So.
Okay. Thank you. I just want to note that in terms of what has been done over the last 10 years, there was significant effort under the Walker administration, including the Assembly GOP Write the Rules project in 2013, 2014, and the Red Tape Review in 2017, 2018. So it's kind of an ongoing thing. 2017, Act 57, adopting the state's version of the REINS Act, all kinds of stuff. So there certainly has been effort prior to this package. Any other questions from the committee? Seeing none? One more. Representative.
I only asked one.
Yep, go ahead.
Before. Just going back, because I think you're absolutely right in terms of, ensuring that it's the legislators' job to listen to their stakeholders and, hopefully draft the bills that have the intentions and are following what the stakeholders are asking. But do you think then there's opportunities for the legislators, and it seems like you work a lot with the majority party, could write legislation that better informs or is a better reflection of the intentions that you have for those bills?
Yeah,
I guess I'm like,
Yeah,
could there be better bills written on,
Yes,
based
absolutely.
on some of your
We're willing to work
intentions?
with anyone that aligns with our mission and goals. So it's like Lucas said, we're a nonpartisan organization. So if there's something you'd be interested in working on that aligns with our goals and our mission statement, we'd be willing to have that conversation.
I will review your mission statement again and see if any of those exist. Thank you.
Seeing no more questions from the committee?
Thank you for your
Thank
time.
you for your testimony.